All right, next case will be KOVATS versus GREGG-KOVATS.
If it pleases the court, my name is Trip Cheek. I'm here with co-counsel Paula Pratt on behalf of the appellant.
Okay. How much time would you like for rebuttal?
5 minutes, please, Your Honor. You've had a case about building the house. You've had a case about selling the house, and this is a case that's in part about how much the house is worth, or at least how you decide that. I'm assuming the court is generally familiar with the facts. This is a dissolution case. What we're really here about, in my view, is three primary issues. A lot of cross-briefing, a lot of things going on here. I want to try to narrow it down for you. I'm going to start with what I refer to as the value of the residence issue. And this is not an uncommon situation. It's a divorce case in which the one spouse, in this case the wife, ended up with the marital residence.
Your complaint is about the date selected by the judge for valuation.
That is correct, Your Honor. And
you understand that a trial judge has a great deal of discretion statutorily in determining the date for purposes of valuation.
Oh, absolutely, the statute says that. However, if you look at the case law and the way it's actually been, the statute's been applied, we don't think the trial judge made the correct decision here. And we do think it's an abuse of discretion, and let me tell you why. What the trial judge decided to do was use the date of the date of separation as the valuation date. And what happened, if you look at the record, is the trial judge made that decision at the close of direct, actually just after the beginning of cross-examination of the wife, who was the first witness in the case. And when the husband's counsel began to inquire into credit card spending and a variety of things that would be relevant.
But I think that the dialogue at that point really was in terms of setting a specific value rather than a discussion about the date of valuation.
Well, and I brought it up here, but I think you're correct. However, I think what eventuated out of that colloquy was this. The judge said, we're going with that date. And while the wife's counsel contends on appeal that there was a stipulation that was going to be the valuation date, that's clearly not the case if you read the record closely. But what did happen was, it appears from what the lower court judge said that she was going to use that date as the valuation date, and she did in fact return to that more than once in the transcript, and that's what she did. And so it certainly appears from the record that she made that decision right up front. The problem with that is that certainly there's discretion under the statute to set what that valuation date is. But the case law says, and this is all cited in the briefs, that the presumption is that you start at the date of trial, and that generally, unless there's a good reason, you use that date for the valuation date. What would constitute a good reason? Well, the rule of thumb here, and this is once again expressed in all the case law, is if we're talking about passive appreciation, a passive appreciation in value, then neither party contributed in particular to that, and therefore the presumption would be they would split that appreciation. So you need to do it toward the time of trial so that they both get the benefit of it.
The Idaho property the evaluation date for that was the date of separation, correct?
I'm sorry, I didn't hear the first
The
one.
Idaho property?
The Idaho property, I think, is a red herring here, Judge. It basically didn't have any equity.
Was there any evidence? Well, there's no equity at the time of separation. We don't know if there was or wasn't equity at the time of trial, correct?
I believe that it was handled with there being no equity in the property.
Let me ask you, the property owned by the parties where the business was located.
Yes.
Now that was split 50-50 by the judge. But did you all ask for that property to be awarded to your client?
I believe that trial counsel did ask for that. I didn't receive that.
All right. What valuation did you all present on that? The separation date or the trial date?
What was the evidence on valuation? Well, I don't think the valuation really mattered because what the judge decided to do was leave him in joint ownership.
No, but during the trial, before you knew how the judge was going to rule, what evidence did you present as to the valuation of the office property?
Let me check on what the valuation date was, but I do not believe it was a date of separation valuation date.
Okay.
And I will get right back to you on that in a
Let
second.
me ask one other thing on that, the alimony. Now, y'all were given full credit as a set-off for retroactive alimony with the mortgage payments, 100% of the mortgage payments that your client paid on the house, correct?
Well, it depends on how you look at it. I think on a dollar-for-dollar basis, it appears that that's what the trial judge did. However, of course...
Well, leaving out the 20% now.
Well, I'm not going to talk about the 20%, but actually I was coming to the same issue, which is he got dollar-for-dollar credit on after-tax dollars, when, of course, so he didn't get to take the deduction. So he did get a credit for it at $300 and something thousand. Of course, it cost him, those were after-tax, so it cost him, had he actually paid the alimony, he could have gotten a deduction, in essence, using pre-tax money. So I would argue he didn't really get a dollar-for-dollar credit on that.
But as far as the mortgage payments, in the way the trial judge did it, in effect, she gets all her alimony going back to the date of separation, and then she pays all the mortgage because he's getting credit for the payments, correct? It wasn't a situation where after separation, half the mortgage was paid by your client, half the mortgage was paid by the other side. So the judge really kind of established ownership in her as of the time of separation.
Well, here's where I'm not sure I would agree with you there. I think going back and giving him that credit actually splits the mortgage payment from a math point of view. But you're correct in that she did go back and give him credit for that. We think the basic problem, we've kind of gotten to another way of another issue, the way I had it broken down, but is if you go back and set early on that valuation date as of the date of separation, it drives the decision-making process, the rest of the case. And we think that it drove some error here that did have a detrimental impact on the husband. There simply aren't any findings in the record to support varying from the date of trial as the valuation date, acknowledging that the statute says that that's within the discretion of the trial court. There has to be something to support it. There has to be some reason either. We don't think that you can even draw it from the record here. There just doesn't seem to be any basis for it. I'll add in some other of the issues in the case. Now, something else I do think is really important to point out here is in our briefing we recite what the law is that applies to the valuation issue. When you look at the wife's response in the briefing, there's really no argument about what the law is on these issues. What their argument is that the husband stipulated to the value and the valuation date and invited error. Well, I would strongly encourage the court to read the transcript closely because that's just not a fair characterization of what happened here. In fact, when you get to page 302 on the closings, the husband's counsel in closing says to the trial court judge, we need to have valuation dates as the date of trial, and it's not fair to give them separate ones. They ought to be done this way.
But these discussions occurred really during the course of the presentation of evidence, and the judge turns to both parties and says, well, we've got this dollar, what do you think? And there really is no seeming dispute at that point as to the valuation.
Well, here's what was going on. I could give you
the fact that later at closing argument he might have taken a different position. Yeah. At that point the trial judge had made that that determination apparently. In the portion of the transcript that's cited by the wife's counsel, here's what they're talking about. As of the separation date, what was the value of the house? Not whether that's the appropriate date for valuation, but assuming the judge is going to use that date, which I contend she'd said way at the beginning of the trial that's what she was going to do. Assuming she was going to use that date, what's the value? There were two appraisals. There was a refinancing appraisal. There was another appraisal. Our side said we have an appraisal for $240,000.
the judge said something like this, sounds like a stip. I mean, you don't know what, people were nodding heads or whatever. Pretty clearly from the context, she was asking the wife's counsel, is $240 an okay value to use at that date? Because that's the only person that responded who said sure, and that was the end of it. It was not a stipulation as to the appropriate date, and this is why, I'll back up, this is why I say that.
But if you have a stipulation as to the appropriate amount, what difference does the date of valuation make?
Yes, but, and this is why I don't know how many cases this court has seen yet, but you're going to see a bunch of them, I suspect. Given the valuation fluctuations in the real estate market, both the high run-up and then the whatever's happened to it now in Central Florida, these timing issues of valuation dates are going to become extremely important. I think they're going to be really, really critical in divorce cases, because what happened is the date of separation was 2002. There's based on the appraisals, $180,000 difference, something in that ballpark, between the value of the house at separation date and the date of trial. So it's a big dollar issue. And so when we get to the end of the trial, this is merely to rebut the stipulation argument, which is really their argument. Trial counsel said he asked the judge to use date of trial valuation dates. He discussed that issue at length. He clearly didn't think there was a stipulation as to using the date of separation. And not only that, opposing counsel did not call him on it, which I would think that opposing counsel would have done had there been a stipulation as to the valuation date. And the trial judge, who's an active trial judge, and you can read that in the transcript, and engages in a great deal of interaction with the court on issues, the trial judge didn't say, hey, wait a minute, you stipulated on that already. It never came up. There's nobody in that courtroom thought there was a stipulation as to what the valuation date would be. What they did think was that the judge had already given an indication as to what she was going to rule.
Let me direct you to the other two issues, because you said you wanted to really argue three issues, so I don't want you to run out of time before you hit the other two.
Thank you, Your Honor. Very quickly, on the business valuation issue. This is the goodwill issue. And what happened was we had competing appraisers. The court decided to, it appears, credit goodwill in the amount of almost $120,000. The problem is, under the case law, as this court has no doubt dealt with, the Supreme Court case of Thompson, which is cited in the briefs, as well as this court's cases of Young and Weinstock, which are more recent, personal goodwill cannot be considered in a sole practitioner professional practice as an element of the value of the business. And
well, you're characterizing it as personal versus enterprise goodwill. Wasn't it on the books as enterprise goodwill?
Well, what happened was
it on the books as
the husband was employed by a corporate practice of medicine type practice. He bought it out. He was an employee at that time.
We know that. Was it on the books?
Right. He credited $55,000.
Was it on the books as enterprise goodwill?
No, it was not on the books as enterprise goodwill. It was on the books as goodwill, whatever that meant. Does that have, is there a legally binding significant characterization there? Well, there's not really any discussion of that in the record. That's their argument, that, well, it was called goodwill. It must have been somewhat enterprise goodwill. That's not, I don't think that's really clearly addressed. But I think the more important issue here is that if you're going to include goodwill of a professional services association in a marital dissolution proceeding, you've got to use the fair market value method of appraisal of a value. And that's straight out of the Thompson case. That's not what happened here. The wife's expert used a book value methodology. And the book value methodology carried the $55,000 of original goodwill, whatever that was in his number of 112. And then the judge, for some reason that is simply not clear at all from the record and not supported by any testimony, added another $60,000 to it. And when
with regard to that original $55,000 that your client paid when he bought the medical practices, now your claim is it's not personal goodwill, correct?
Our claim is that it was not established that it was enterprise goodwill.
All right. Well, what was it? I mean, your client said it's kind of to avoid aggravation, but I don't think in valuation there's a factor known as avoid aggravation value.
You know what? I think it's in the Walton case has a really good explanation of this. The Thompson case deals with it as well. You know what goodwill is? Goodwill is the difference between the value of your assets and what you pay for it. That's goodwill. And the case law even recognizes that simple business reality.
Well, isn't that what he did when he paid
Sure.
for?
That's what it is. That's what he did.
Okay.
Is that enterprise goodwill, however, enterprise goodwill is a value that is carried by the business, by the name of the business, by the reputation of the business, by that business's ability to continue to generate customer flow or client flow or what have you. That portion we don't see in the record, that was what was carried through at that time, and it's their burden.
Well, what is it then? I mean, because it seems to me that he's not paying the $55,000 for his personal goodwill. He wouldn't, and he's paying himself for his value. So he's not paying it for personal goodwill. He's not paying it for assets. So what's left?
Well,
you just told me that goodwill is the difference between what you pay for it and what the assets are worth.
that's right.
So that's $55,000. If it's not personal goodwill, what else is there besides enterprise goodwill?
It's an additional payment that was necessary to complete the transaction that was characterized by the accountants as, quote, goodwill.
Okay.
What it is for purposes of this, well, I don't believe it's been established. But I'll say this.
Well, the judge
it couldn't have been personal
the
goodwill
judge couldn't
because...
take that determination as a finding of fact?
Let me back
By the
up.
way, you're
I don't want to avoid your question, but he was a doctor in the practice at that time, too, so if it was personal, it probably carried with his person. Thank you.
Okay.
Good morning. My name is Marcy Lippincott, here to represent the appellee and the cross-appellant, Leslie Kovats. Notice the former husband contends that the evidence of enterprise goodwill is completely absent from this record because no one would buy his medical practice without a non-compete clause. But his entire premise is completely faulty. If the trial court did not find that enterprise goodwill in the entire practice, if it had, the value would have been $315,000 rather than $172,000. The enterprise goodwill that she did find had to do with the purchased enterprise goodwill. And the husband's argument about that completely falls when you look at page 240 of the transcript. I have it right here, page 240 of the transcript, where their own expert admits that the purchased goodwill was in fact enterprise goodwill.
Let me ask you this, Ms. Lippincott. I understand how the trial judge gets to the 112.
Yes.
What's the evidence supporting the additional $60,000?
Yes, Your Honor. I have a point I don't want to waive about that with respect to that issue not properly being before the court. But to answer your question, the evidence before the court with regard to the 172, the difference between the 112 and that, is not exact. I'll give them that. However, there is sufficient evidence for the court to make that determination, and here's the way that you can arrive at that conclusion. There's no question but that this was the price paid in 1998, right? That's a long time ago. There's evidence in the record that the practice grew substantially. For example, in the year 2000, the revenues were approximately $700,000. In the year 2003, the revenues were almost $1 million. In addition, we have the value of the entire practice, including all of the goodwill, at $315,000. So certainly there was evidence here showing an increase in the purchased goodwill. There was no exact figure of 172, but there was evidence to support that this purchase goodwill had indeed increased, and there was information there from which the court could have extrapolated the 172 figure. But more importantly,
what is that? I think that's what the question is. What information is that?
there is no exact, as I said, and I admit, there is no testimony in this record that you'll find that supports the exact figure of 172. And in some of the cases that I cite in my brief, there is no exact testimony there to support the exact figure found by the trial court judge. But what the courts did in those cases was to look to see if there was any competent evidence to support around the figure, and there was. And here, there's competent evidence to support around the figure in that there's no question but that the practice increased in value substantially from 1998 till the time it was valued. But more importantly, Your Honor, we contend that this issue was waived. It wasn't properly brought before this court. Judge Ployce, you know, you were on the panel in Florida Emergency Physicians, and you know that, they say just ignore this rule. In fact, they didn't even talk about it with you. You can't raise a point and say their point on appeal was that there was no goodwill, that it didn't exist. And then they try to change that into, well, maybe it did exist, but let's challenge the value. Well, they're the appellant. They have the burden. And they didn't properly raise that issue, and we shouldn't even be talking about it. And even if we do...
Are you saying because they didn't file a motion for rehearing or on that issue?
No, Your Honor. I'm saying that in the points on appeal, their point on appeal, their sole point on appeal regarding goodwill is entitled this: why failed to present substantial, competent evidence of any enterprise goodwill in the medical practice. So they challenge on appeal the existence of goodwill. They do not challenge the value. Now, they suggest that you just ignore these rules and throw them away. But the rules are there for a purpose. It's their burden. They're the appellant. The appellee in this court should not have to guess what the issues are. That's a simple matter of due process and fairness. So we contend, Your Honor, that that issue is simply not properly before the court.
Counsel, there's a couple of cases from this court that seem to indicate that when the court does not set a date for payment or establish a reasonable payment schedule or payment security, that it may be a breach of or an abuse of discretion. Would you agree with that in this case, that those omissions?
Yes, Your Honor, you're going to one of my points on cross-appeal, and absolutely we do. The wife was awarded $132,000 approximately in a back child support, back alimony, an equalizing equitable distribution payment. In addition, she was awarded attorney's fees, but there was no date for payment. There was no payment schedule, and he's been given quite a long period of time now. And we know at the attorney's fee hearing, no payment. Absolutely, that should have been done, and it was an abuse of discretion.
If we agree with you on that point, do we just say, trial judge, do something, or do you believe there should be additional directions?
I think there should be additional directions, Your Honor, due to the length of time that's expired in this case. I believe it's almost 2 years. It's time to pay. This lady incurred debt during the lengthy separation here of almost $100,000. Those interest charges have not stopped. At the time she did her affidavit, they were approximately $629 a month. By the time this all gets said and done, she's not going to have much except that house. And what is that house worth? There was testimony here that that house needs major repair. I don't care about a value on a piece of paper. Who cares? This is where the lady and the children live. This is all they've got. And I cannot believe that counsel can stand up here and say that there was no stipulation made with respect to the value here. I've set that out, that testimony, that colloquy out extensively in my answer brief. Absolutely there was a stipulation, and more importantly, there was invited error on this issue. And from the very first thing out of counsel's mouth in opening statement, he says, if you decide to value it, the marital home, at the date of separation, fine. And those kinds of remarks are repeated throughout this trial, from the very opening statement to closing argument. Your Honor, that is invited error. If there is any error here, it was stipulated to, it was invited, end of story. Interestingly, he makes no argument with respect to the alimony arrearage calculation, and that's frankly because he doesn't have a leg to stand on. In addition, he made no argument with respect to the attorney's fees, again because he has no leg to stand on.
Let me ask you, on the attorney's fees, is there a disparity between the judge's oral pronouncement and the written final judgment with regard to 1/3 of the $22,500 already paid?
No, Your Honor, I don't believe so. And again, that's another one of those issues that was not properly raised. Again, the point on appeal regarding that issue is the wife had no need for husband to pay any portion of her attorney's fees and costs. That's the point on appeal. Anything else was not properly raised. Now, moving along to the issues on the cross appeal. We contend that, there's no question here, and they don't challenge the fact that there was a large alimony arrearage of $312,000, stands unchallenged by the former husband. He was successful in getting this reduced by a 20% so-called tax credit. He claims in his appeal that that wasn't enough and asked for 28, but then he doesn't argue it here. We contend that there should have been no credit that had been given. He couldn't find one case to support this tax credit. That's because it shouldn't have happened. The former wife needed and the husband had the ability to pay these monies. The so-called tax credit fails to recognize the reality of the party's situation. It has no support in law, logic, or equity.
Well, let me ask you this. This is kind of an unusual situation.
Absolutely.
Because there's testimony that the parties, have they filed the joint tax returns?
They chose to file joint tax returns.
Okay, so leaving out all the set-offs, et cetera, let's just say there's, the court says you owe $300,000 retroactive alimony. So he cuts her a check for $300,000. And it covers the years that they have filed joint tax returns. Does she pay any tax on that $300,000, or is that already covered by the fact that they did a joint tax return?
I think that's covered by the fact that they pay a joint tax return. She doesn't. But what she does pay is all those carrying charges, all the money that she had to borrow.
All right. I mean, that's a separate issue as far as the interest she paid because of...
Well, it's not really a separate issue because it's the only way it's going to get taken care of. The only way for her to retire that debt and to recoup all the monies, she's never going to recoup it, but to try to lessen the impact of all those years of interest that she paid is in the money that he'll have to pay.
Well, let's assume she wasn't paying interest on borrowed money. With the $300,000 in that situation, if you pay retroactive alimony, $300,000 for years in which there are joint tax returns filed, would she pay any tax on that $300,000?
I don't believe so, Your Honor. In addition, she wouldn't get the deductions from paying all the mortgage on the family home. And Your Honor was exactly right. Dollar for dollar, she's paid for that home since that time. She'd have got no tax credit for that. I mean, what's fair for one is fair for the other. And this was not fair. In addition, we also maintain that the trial court did err in not awarding all of her attorney's fees and costs to her. Your Honor, here we have a woman who was age 52 at the time of trial. She'd given every one of her career building years to this family. The major asset she was awarded was a heavily mortgaged home used as the residence for herself and the minor children that was badly in need of repair. Even after alimony, the former husband's income was almost 3 times hers. So there's no question here that the wife had a need and the former husband had the ability to pay, and she should be awarded all her attorney's fees, and all the monies that she was owed here, this court should order them to be paid now. He's already had much too long. Thank you very much.
Thank you.
Please, the court. Thank
4
you.
minutes and 10 seconds.
Thank you, Your Honor. I'll talk fast. As you're aware, the fact that I didn't get to something doesn't mean we're giving up on it. going in reverse order, the wife, in fact, has a law degree, as you'll know if you've had that.
She's never practiced law.
Yes, but if you'll read the testimony, she chose not to, and did not do so for 6 years or more before the family unit started. So, her decision.
Well, it was a joint decision of the family unit.
At some point, I suppose that's true, but they weren't married when she made the decision initially, and that's in the record. This decision is messed up. There's various things wrong with it. If you look at Record 370 when you get there, when they went back and the final judgment was drafted and there were some things that were objected to, the trial judge essentially acknowledged that she could not understand why she had given the numbers she had given on some of these points. In particular, that relates to the $60,000 issue. And I understand it's a complicated, difficult case, and there were a lot of things going on, but we think it needs to be sent back and corrected. Now, 2 primary legal points, not argument, not going back and forth on these things. Number 1, under the absolute Supreme Court case law in Thompson and its progeny that this Court follows, in order to consider goodwill in the valuation of a professional services corporation, you have to use the fair market value manner of appraisal. The trial court judge did not do that. She accepted the wife's expert's book value, and then she added more goodwill to it. Thompson says you can't do that. So the wrong appraisal methodology was used.
Do you agree on the alimony that there would be, on the retroactive alimony, no tax consequences?
I don't know the answer to that. But I do know this. One of the things about, alimony is the husband, in this case, is going to have, let's say, a 28% tax rate. The wife, I think the testimony, she had a 20%. Of course, the husband gets a deduction for that, and the wife has to take in his taxable income. The spread between those tax rates is always going to create a difficulty. And one of the things that happened in this case, I think, is in getting into it on appeal only, is when the judge decided early on to set that valuation date early, sort of set down a path where this problem was eventually going to occur. And what the judge did was try to use credits and offsets and discounts. And by the way, the wife's expert said, yes, there's got to be some kind of tax credit here. So it's not something that came from the husband's side purely. But what happened was the judge had to then try to do offsets and credits to equalize it all. It shouldn't have been done that way. And if the valuation dates hadn't been picked, then the numbers would have worked right and we wouldn't have had this issue. So
Let me ask you this, follow up to Judge Boyce's question. Was the judge required to set a time for your client to pay the amount of money to equalize distribution, equitable distribution?
we don't challenge that issue.
All right. Any suggestions on remand, whether there should be, what direction should be given to the trial court on that issue? Should we agree with some of your arguments, some of theirs? Maybe the amount will change, but let's assume there's an amount owed by your client to the opposing side.
I think that our suggestion there is that just like we will on these other issues, the judge can make an equitable decision here. We don't have a problem with the judge doing that. Thank you, Your Honor.
Thank you.
Let's take a break.